Everyone, thank you so much for taking the time to join me on this call. Today, we are going to talk about the basics of living trust, and specifically that component in estate planning to really plan for your future and make sure that later on down the road, not only is it less hassle for your family, but that you're also better protected during your life, that your assets are better protected, and you basically set yourself and your family up for paying less taxes down the road. So I'm really excited to be here with you today. I think that living trusts are something more people should have information on. Until the last few years, when I really started becoming more involved in the financial planning industry, sidestepping more from just business consulting and whatnot, I was not as familiar with living trusts. I thought that they're mostly for really rich people or people who had really big estates. And I had a whirlwind education and now am very, very passionate about helping my clients set up these trusts because they offer so many different protections and they do so many different jobs for us. Most importantly, when it comes to protecting the family, keeping things internal, avoiding the probate process, which we'll talk about more, and paying less in taxes as well too. So let's just start off. I'm not going to take up too much of your time today. It's going to be a pretty quick and to the point presentation so that you get some different seeds to sort of think about and plant if you want, and really just figure out, what are you playing with? Continuing with this analogy, essentially with your garden, you get the option of sowing the seeds so you can reap the benefits later on in life. And if you don't do that, there's nothing to reap later on. So what I really want to tell you about is living trust so you can make a good informed decision for yourself. So a living trust is essentially an entity separate from yourself, and how we set it up as a living trust and a revocable specifically means that you can change that throughout your life. It's not set in stone. And in addition to that, you still have full control of a living trust. You and your spouse are the primary ones who are able to essentially fund the trust by adding various assets and whatnot. But by creating the separate entity and retitling assets under the name of this trust, let's say my name is Freilich, we have the Freilich Family Trust. I'm going to retitle assets from under Amanda Freilich into the Freilich Family Trust. And now I don't own anything on paper, but my trust still controls it. And furthermore, it's a lot more protected than if it were just in my name. Now, what that does when we move assets from being underneath our names into a living trust, which again, we still have full control of, is it helps us avoid the probate process. Now, probate essentially is the process where a will, if that's all someone left, is going to go through the court so they can determine basically who was notated as receiving what should receive what. The issue is when the courts are in control, it typically takes between 6 to 18 months in that probate process. And throughout that entire time, it can be very, very expensive, just adding up with the different lawyer fees and the court fees, not to mention emotionally exhausting and very time consuming. So probate for a lot of people is a 4-letter word. It's something that we want to avoid. And I can tell you, I'm helping clients right now go through a process post-death with a relative who thought he had everything buttoned up, but because he didn't have it in a living trust, they're still essentially having to go through this process of retitling assets, and hopefully we're going to help them with a much simpler probate process as well too, where they don't have to use a bunch of different lawyers and whatnot. And that's part of what we help people do as well too, is just walk through that process. But the most important part going on with this, with the living trust, is so you avoid the probate. It gives you the control, not the courts, over the assets you leave to your heirs. So when someone just writes a will, anyone can go to the county courthouse and go get that will for $15, and they can contest it. When you have a living trust, and a will is one of 12 documents that we help put into one of those trusts, it is private. No one can go down to the courthouse and see what's on that will. Furthermore, if someone wants to contest anything regarding the will, they'll have to essentially sue everyone in the trust as well too. So it gives you and the people you want to leave your assets to way more control, which is quite amazing. So why does a revocable living trust avoid probate and prevent court control incapacitation? And that's an important one we'll come back to in just a second. As I just mentioned, there's nothing in your name, so it's in the name of the trust. As a result, there's nothing for the courts to essentially move out of your name. It's that simple. It avoids that process. Do you lose the assets or control of the assets when you put them in a living trust? Absolutely not. So as I mentioned before, you are the owner of this trust. It is an extension of yourself, similar to like an LLC, a business extension as well too, but you'd still be in control of that. And it's tied to your social security number. So it's not like it's going to float away and you won't be able to track it down or have control over it. And although John D. Rockefeller might not have been the best person in the world, he understood trust, and he and many other families utilize these tax shelters to essentially, not excuse me, tax shelters, these very controlled and protected environments essentially to control their assets. And that's why he said, I own nothing, but I control everything. Really, really wise words right there. So people involved in the Revocable Living Trust, let's just go through the roles and how that essentially works. You're going to have the trustor, that would be you, the grantor, the creator, the settler, the person who sets up the trust. Until you are either incapacitated or pass away, you are the one who has full control. If you and your spouse are both trustors essentially, and you set it up for each other and you're registered agents for each other, you'll both have control. When something happens to the other person, that individual will then essentially step up and will need to become the successor trustee. So the trustee, this is you while you are living. The successor trustee is the person you will name in your trust to handle your affairs. The trustor, again, once again, you and your spouse will be fully in control of your revocable living trust. Should something happen to both of you, that successor trustee will then come in, and they will be the person, the fiduciary responsible for settling your estate, closing your affairs, and they have to follow the legal documents in the trust to a T because that's how it's outlined. It's beautiful. It gives you control. And then, of course, the beneficiary are the people or organizations who will receive your assets. So there's some other benefits to a living trust. It's not just about when you die. And I want to point this out really quick here as well, too. If you were suddenly incapacitated and unable to manage your day-to-day affairs, do you currently have the documents in place to relieve your loved ones of the liability of managing your day-to-day affairs? And that includes accessing the financial institutions to be able to pay for the various day-to-day responsibilities. For most people, this answer is no. That's also why a living trust provides so much benefit, because we help put the proper documents in place, including the power of medical, power of attorney. And what this does is it helps the individuals around you have the correct authority in the event that you are incapacitated, not dead, to be able to manage your affairs and conduct your wishes as you desire. So if you have specific medical wishes, like I don't want to be on life support more than 7 days, that can be outlined in your trust as well too. And it really just brings you a lot more control. So jumping back here a little bit, what happens when you die? Well, this is when the successor trustee will settle your trust. This is the person that you name, again, that fiduciary, who will be responsible for taking the necessary steps to settle your estate. As just mentioned, if you were to become incapacitated, your successor trustee, or in some instances, your spouse, the other trustee as well too, can manage your affairs based on the instructions in your trust. And those are legally binding documents, so they have to. And who decides if you're incapacitated? This one can definitely trip up a lot of people. They don't want a situation where someone says, oh, you're unable to manage your affairs, you have to go into a nursing home. No, that's not the situation. And you can actually name the authority to determine if you're incapacitated or unable to manage your day-to-day affairs. You can have a specific doctor that you want to be the individual to determine that, or it can be something as simple as losing 2 out of 6 ADLs and having some different plans in place for that. Why can you be sure your successor trustee will follow your instructions? As I mentioned before, a trust is legally binding. So when that individual signs it, they're signing up to do exactly that. So we can do all of the hard work of getting the living trust together, creating those documents, everything else. But once it's set up, it has to be funded. And I don't mean you have to put a whole bunch of money into your trust. I'm talking about retitling your assets so that they are now in the name of the trust, or else nothing changes. Again, the purpose of a trust is to create maximum protections and control so that when something should happen, whether it's incapacitation or a death, nothing essentially is in your name, but it's in the name of the living trust. So you're able to help your family avoid the probate process and outline essentially who should go to what, how you want it done, get more control, all of that. It's important to change beneficiary designations because that gives you maximum control. So if you had a falling out with someone 10 years ago and you don't want them in your trust, change it. You have full control to do that. And of course, there are some different strategies we can talk about as well too, in terms of retitling different savings accounts and plans into that trust as well too. So just kind of recapping, why do we want to avoid the probate process? Well, folks, as I slightly mentioned before, probate is a process that can last between 6 to 18 months in most states. And as a result of all those lawyer and court fees, it typically reduces the value of the estate by between 8 to 12%. That's a lot. That's a lot. And it's time consuming, it's emotionally exhausting, it's difficult for a lot of people to navigate the system, and that's why lawyers are getting paid so much. But on the plus side, when we help you set up a trust, we're there to help you through the process. We're not going to charge you more later in life when something happens and it's time to retitle assets. This is a one-time setup with all the 12 documents you'll need in a fully comprehensive trust to have maximum control. And of course, I mentioned before that a trust is private. It is not public record like probate. So you're not going to have that will just available for anyone to go down to the county clerk house and purchase for $15. So I bet you didn't know this, but if you have property in multiple states, you're going to have to go through probate in most states if you don't have a trust and you don't have a plan in place. Fortunately, your trust can control all of your assets, even real estate you want in other states. So that's really helpful. Again, keeping in mind that that probate process in one state is 6 to 18 months. So if you go through that in multiple states, that's going to add up. And of course, we want you to have maximum control, which is why your handpicked successor trustee can immediately step in for you. There's no court involvement. We have those documents in place, so it's not this huge, hairy mess. No one wants that. And there are some other really incredible provisions you can put in a trust, literally everything from spendthrift provisions to minimize the amount of money certain people receive if they're having, like let's say like substance abuse problems, or they're really just not good at handling money. You can dictate that they take a financial planning course or that they go to rehab before they're eligible to receive various assets or money or anything that you want to leave to them. And so it gives you maximum control. Same for minor children. Let's say that someone passes away and they would leave $18 million. You don't want to give that to a 17-year-old. You want to break that apart. And I mean, even if we're talking about $200,000, that's still a lot of money. I wouldn't want to give that to an 18-year-old and say, have at it. We can put provisions into the trust essentially so that there are milestones that that individual reaches during their lifetime. And once they essentially reach that age, then they get another disbursement until it's gone. And that fiduciary or successor trustee is the one who would manage that. So let's just recap on some of the benefits of a revocable living trust. So you control when your beneficiaries inherit. They can be distributed right away, as I was just mentioning, or they can stay in the trust until the age you determine. If you really want, you could disperse, a certain percent every single year. That would suck for the successor trustee because that's a lot of work, but you could do it. You could also say until you're 50 years old, you won't get anything. You have all the control. That's kind of the point here. It's more difficult to contest. So as I mentioned before, a trust is private and the contesting heir must hire an attorney to sue every beneficiary in that trust individually. So it's not a cheap process, and it's one that would really deter most people from trying to go after that and contest a will. And of course, it is so much easier for your family. When you set up a living trust, you are essentially pre-probating your entire estate. You are avoiding all of the different taxes that you would have to pay, when we're talking about capital gains, passing land on to various family members. You're avoiding the probate process and the court and the lawyer fees of having to have everything transferred out of your own name because you've already transferred it into a revocable living trust that can pass it along to the family as you dictate. And just recapping, this is about control. So most people, they go through their lives just taking one step forward, 2 steps back. They're trying to get ahead and they're in very unhealthy cycles where they feel like they don't have any to little control over their financial health and their financial wellness. With a revocable living trust, and this is one component of the foundational planning approach that my firm and the Wealth Store utilizes, what we can help you do is receive full control. You can get full control over your assets, over how you want your medical and personal affairs to be handled in the event of incapacitation and or death. And it really just sets your family up for a lot less emotional and financial hardship down the road. So overall, those are the primary benefits of a living trust. I would be more than happy to jump on a call one-on-one with you to really dive into more about, what are the benefits here? How are they utilized, personal versus business? There's so much we can do to help give you control back over your finances and your assets. At the end of the day, my job here is just to provide education. So if you have any questions, please reach out. I really look forward to hearing from you, and I appreciate your time. So thank you so much.